Welcome everyone. Thank you for joining us this afternoon. I'm Nikki Jovicic from LookUpStrata, and for this Victorian Q&A webinar session, I'm joined by Gregor Evans from the Night. Thanks for joining us today, Gregor. We're very excited for this Q&A webinar as it is the first dedicated Victorian webinar we have held. It's a big year for owners corporations in Victoria with the change to the legislation coming later this year. No doubt we will be touching on that during the session, as well as many other topics covered by the questions we have received from you, our audience. Please feel free to share this recording with neighbours, committee members, other staff members, or anyone you think who will be interested in the session. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent advice before acting on the information contained in this session. I'm delighted to introduce our panellists today, Gregor Evans from the Night. Gregor started with the Night in 2005, initially gaining experience in the industry in administrative and support roles, and working his way up to hold the position of Owners Corporation Manager and Business Development Manager. In 2018, after years of planning and preparing the business for future growth, Gregor was promoted to the role of Managing Director. Today, Gregor's mission is to improve the reputation of the strata management industry, holding the position as President of the Strata Community Association Victoria, advocating for better standards and improved transparency for all industry stakeholders. The team at the Night are regular contributors to LookUpStrata, providing both Victorian Q&A responses plus topical articles. They are featured in the latest edition of the Victorian Strata magazine with their article, Upcoming OC Act Changes for Committees to be Aware of, which provides an excellent summary of the changes to the Victorian Strata legislation later in the year. Welcome, Gregor.
Thank you very much, Nikki, and thank you for that introduction. Lovely, as I said before, lovely to be joining you this afternoon, and we're very fortunate to be involved with LookUpStrata and providing insights to and helping out owners with their queries that come to you over, I guess, over the last couple of years we've been involved. So first time I've been doing a Q&A with you, and I'm looking forward to, as I said before, looking forward to answering plenty of questions, and then hopefully I can provide some insight and some good responses, but we'll see how we go.
We've got some interesting ones in there as well. So are you ready to get started?
Yes, I am. Far away. Please do so.
Excellent. Okay. In allocating bills to unit holders for expenses such as owners' corporation fees or cost of maintenance projects, is there a principle, guideline, rule or legislation that applies? Do bills get equally divided between all members of an owners' corporation, or does the size of each unit determine the allocation?
Alrighty. Okay, so when it comes to the division of owners corporation fees, or the apportionment of owners corporation fees, it comes down to what is stipulated on the plan of subdivision. So whenever a parcel of land is subdivided into private lots as well as common areas, a plan of subdivision must be created, and that is registered with the Land Titles Office of Victoria. So what happens there is that a land surveyor will prepare that plan of subdivision, and they will allocate what is called units of liability to every individual private lot on that plan of subdivision. So sometimes lots have equal units of liability. However, at other times, those units of liability do differ, and it does, I guess, come down to sometimes the size of the lots. Also the location of the lots, whether if it's an apartment building, it could be that a lot towards the top of the tower has more units of liability than the lot on the ground floor, because the people residing in that lot utilize the common areas more than those on the ground floor. So for example, it could be the lift. The ground floor occupiers don't use the lift, whereas the others do. So it's the responsibility of the land surveyor to determine the units of liability and the calculation. And there was a change to the Subdivisions Act recently, where it specifies that the reasoning must be provided with the plan of subdivision as to how the units of liability are calculated. I can go on this a little bit more. There's also units of entitlement, which are also prepared for each lot, and sometimes the units of lot, entitlement and liability are the same. However, typically speaking, units of entitlement should be based upon the value of each lot, whereas the units of liability should be based upon the usage of common property. So typically these days, I'm dealing with a lot of land surveyors. They look at how many bedrooms within an apartment potentially, or an office, how large an office suite is if it's part of an owner's corporation, and work out the size and the number of bedrooms to determine how many units of liability that lot should have.
Okay, and we've just had a question come in that's
Sure.
related to that Q&A that we've just answered. So I might just ask you now, Gregor, and the question is, does the new buyer's OC fee, is it lower than the previous buyer's OC fee?
Is the new buyer's OC fee lower than, I'm not quite sure exactly.
I think they're asking is if you're purchasing a unit, does the OC fee stay the same regardless of who's actually owning the unit?
So in terms of, for a brand new development, what happens is that the developer will prepare a budget for that property, and that's for usually a year, an annual term. And when someone purchases the apartment, they should be getting the Section 32 document, which entails the owner's corporation certificate. So that would basically identify the owner's corporation fees for that lot. So when someone buys in, they'll be responsible for the balance of the fees for that remaining year. And just, I guess, a bit of a side note on that, if there is a debt with the lot, that debt stays with the lot, and therefore the purchaser would take on that debt. However, when the settlement of a property occurs, there's what is called the statement of adjustments, where the conveyancer will typically reimburse the owner's corporation for the outstanding amount. So hopefully that answers the question. Yeah. And just also a bit beyond what I said before, if there is works undertaken to either common property or a lot, which is wholly or substantially for the benefit of one or many lot owners, but not all the lot owners, then though the cost of those works can be invoiced to that group of owners who benefit from the work. So, but basically, it's based on units of liability in the first instance.
Okay, excellent, thank you. Okay, we'll move on to the second question. We recently had a vote regarding replacing leaking windows in a building where I own a rental unit. The required improvements would cost each lot owner $30,000. I voted no, as my unit is not affected by the problem. At our recent Owners Corporation meeting, the Owners Corporation manager pointed out those of us who had voted no. This has caused some ill feelings and hostility towards us. I was under the impression my vote would be confidential.
Okay, so when it comes to confidentiality of voting, my understanding, and I wish to reiterate your comments at the start of this Q&A, that I'm not a lawyer, but and therefore my answers are of general nature. But my understanding is that any voting of an owners corporation is not confidential. So it's a requirement of an owners corporation to hold records of votes that occur, and therefore any lot owner or representative of a lot owner can inspect those records to understand who has voted in regards to that motion and which way they've voted as well. So in terms of secret ballots, my understanding is they just can't occur. I guess just to dissect that question a little bit further as well, when it comes to the cost of the window replacement, really important that the owners corporation is checking the lot boundary on the plan of subdivision or the strata plan. At times, owners corporations have got themselves in trouble where they've actually undertaken works to windows that are located on private property. And there is a story in the industry where an owners corporation did the works, the contractor didn't do a very good job. The owners corporation found out that they shouldn't have actually got involved, but then they were liable for getting another company in to rectify the works because they approved the works initially. And so when it comes down to the boundary of a lot, there's three key principles. It's either the internal face, the median face, or the external face of the lot. So really important to check the boundary. And then also my answer to the first question regarding whether works benefit an individual or a group of people rather than everybody. Potentially the window repairs could be a benefit to only those people. However, the question to ask is that if by I guess undertaking maintenance works to the external face of part of a property is going to benefit all owners because it's going to increase the value. It's a complicated, I guess, situation, but really important for the Owners Corporation Committee or the Owners Corporation to consider whether it's a benefit or not to, as I said, a group of owners.
Okay, wonderful. And just speaking about that too, Gregor, with regards to the necessity to replace the leaking windows as well and the obligation to the Owners Corporation to upkeep the common property?
Certainly. So in terms of if it's common property, the Owners Corporation is required to maintain common areas of the building. So there's no way out in terms of doing the works. Yeah. But when it comes to private property, if a lot owner hasn't undertaken the works, then the Owners Corporation has the ability to issue a notice to that lot owner to rectify if it's affecting the external appearance or the enjoyment of other lots within the Owners Corporation.
Okay. Okay, we had another one. We had our AGM recently, and when the minutes were sent out, a number of the items were minuted incorrectly. How do we correct the errors? Do we have to wait until the next year's AGM when we pass the previous year's minutes?
Sure. So I guess at times the minutes are written, whether it's by a chairperson or a delegate of the Owners Corporation, or at times the Owners Corporation manager will write the minutes as well. And yes, at times the minutes may not get everything right in terms of what was discussed and agreed. So I guess if it's immaterial to the operation of the Owners Corporation, my suggestion would be to wait until the next AGM to raise the issue and ask that the minutes are rectified. If a person believes that what has been written or recorded in the minutes may have a material impact on the operation of the Owners Corporation, my suggestion would be that they inform the Secretary of the Owners Corporation, and that may be the manager, in regards to what they believe is incorrect, and ask the manager to consider. It may be that the manager is unsure as to, or whether it's a committee member as well who wrote the minutes, whether they're unsure as to what was actually agreed, and therefore they may defer back to the owners or the owners' representatives who were in attendance at the general meeting. They may also go back to the committee and get some feedback from them as to whether they believe what is being contested is accurate or not.
Okay, thank you. We have this one. It's quite a complicated one. It's to do with redevelopment and a buyout proposal. We live in an ageing 2-storey strata title block of 24 units built around 1970. There are 2 separate brick buildings. The complex has big external common areas. Maintenance and upkeep of these areas takes up to 29% of the budget. We have extreme maintenance and repairs that need to be attended to, including leakage issues, drainage problems, cracks and movements, etc. Repairs and maintenance of the building are currently 21% of the budget, rising every year unless extensive remedial works are undertaken. There's currently no sinking fund. Our units are at the lower end of the market, both in cost and rents. 25% of the lots are owner occupied, and filling rental vacancies during COVID has been problematic. Is a redevelopment buyout proposal too dramatic for our situation, or what can we do?
Yeah, an interesting question. Look, I guess it comes down to the appetite of the other owners, and if it makes sense that it's going to be a lot easier and cheaper for lot owners to sell the property collectively rather than having to deal with the maintenance issues and constantly upkeep the property, then a buyout to a developer could make sense. So it's about surveying your fellow lot owners and seeking their feedback as to whether they would be, I guess, keen for that scenario to occur. Up in New South Wales, there's legislation that has been introduced recently. I understand that it only requires 75% of owners to agree to sell the property, as long as a few other conditions are met. However, down here in Victoria, the threshold is still 100% of owners, which is a unanimous resolution to agree to sell the property. So I guess if you can't get that support from other lot owners, then it may be worthwhile for you to consider whether you sell the apartment yourself to get out of the future obligations of the maintenance requirements.
Okay, thank you. What exactly should we expect from the Owners Corporation Management Company for the amount that we pay? What level of service should be included?
Sorry, Nikki, sorry, can you just repeat that question again?
It was, what exactly should we expect from an Owners Corporation Management Company for the amount that we pay? What level of service should be included?
Definitely. Look, this is really, how long is a piece of string, because different Owners Corporation Management Companies will offer different services. So I guess the fundamental services that an Owners Corporation Management Company will offer is administration work, secretarial duties, arranging meetings for the Owners Corporation, attending to the financial obligations, so paying invoices and recording all the accounting transactions, and then producing the financial reports for the Owners Corporation. Also dealing with insurance as well is vital, making sure that the Owners Corporation has adequate insurance for the property. So I guess they're the fundamental services for an Owners Corporation manager. Others will get involved in dispute resolution, also dealing with other maintenance works as well. So getting quotes on behalf of the Committee of Management and producing those, preparing those quotes, doing a summary, and providing them to the Committee of Management. So in terms of the structure of Owners Corporation fees, they do differ amongst companies in Victoria. So some companies will actually include the core services, and a lot of the additional services other companies would charge extra for under the one management fee, whereas other companies will charge a low management fee for those core services, but then will charge extra for every single other service that the Owners Corporation Committee wishes for them to carry out. And then on top of that, there's also the cost of disbursements as well. So disbursements covers things such as postage, phone calls, those types of things that the Owners Corporation manager will incur on behalf of the Owners Corporation, managing the Owners Corporation. So, and then on top of that, there's one additional revenue stream, which is insurance commission. And insurance commission is prevalent in the industry, and basically the Owners Corporation manager will take a commission from the base insurance premium of the Owners Corporation's insurance policy, and that helps to subsidise the Owners Corporation management fee. There are plenty of companies out there who will opt not to take insurance commission, but that will result in their management fee increasing and the Owners Corporation insurance premium decreasing slightly. So getting back to I guess the question, the fundamental services to expect certainly, and then a few of these other additional services. Also a point to make in regard to that question, Nikki, is that there's different disciplines in terms of you've got Owners Corporation management, you've got building management, facility management. So especially for the larger properties, you have a dedicated building manager and then an Owners Corporation manager as well. For a lot of the smaller properties, there won't be a full-time or even a part-time building manager, but you however, have an Owners Corporation manager. So I guess a lot of owners probably believe that the Owners Corporation manager should fulfill the role and be that quasi-building manager at times. So it's a very different discipline. Some companies will purport to provide some of those services, but just be mindful that that's not part of the core responsibilities of an Owners Corporation manager. And when it comes to building management services, that's attending the property, supervising contractors, dealing with resident queries on site, those types of things. So I guess that's the answer to that question.
Okay, and when you mentioned about the different ways that people can prepare their quotes for tenders as well, it's quite important that the committee looks at the total costs, isn't it, rather than just a base fee plus disbursements.
Yeah, definitely. I think it's really important for a committee, if they're looking to appoint a new manager, to understand exactly what the additional services are going to be and what they're going to charge for, because as I said, at times managers will provide a low fee and then charge excessively for additional services. So it's really important to dig deep and understand what the full cost is going to be. And a lot of committees will come to us saying, can you provide an all-inclusive fee? And we can do so minus a few additional services that we just can't budget for, potentially attending a VCAT or attending a site or committee meetings, unless they provide a good understanding as to the time for attending committee meetings. We wouldn't know what the charges are going to be. So it's about getting as much information as possible, understanding the committee's expectations, the owners corporation's expectations, and then costing it based on that. So, yeah.
Okay. Well, we have one that's come in. It's to do with voting and voting rules. If members of the committee own more than one lot, what are the voting rules? One of our committee members owns 2 units in a block of 12 units. There is some confusion as to whether she's entitled to 2 votes at committee meetings. Are committee members entitled to vote according to their lot entitlements, and is it similar to voting at the AGM?
Good question. And I've had this a bit over the years. So when it comes to committee voting, it's very different to voting at a general meeting of the owners corporation. So at a committee level, it's 1 vote per committee member. So if you own 2 or more lots, basically, and you've been elected to the committee, it doesn't matter how many lots you own, you only have 1 vote as a committee member. So at times, if you own additional lots, people may wish to proxy somebody else to be elected onto the committee, but each of those persons can only have 1 vote at the committee level. When it comes to voting at a general meeting of the owners corporation, in the first instance, it's 1 vote per lot. However, there's the ability to call what is known as a poll vote, and that's a written vote at the general meeting level, and that's based upon the units of entitlement.
Okay, thank you. All right, we're moving into, we've got a request for COVID safe plans for Victorian Strata. So new government regulations have been announced that owners corporations need to have a COVID safe plan in place, which was effective from the 30th of March 2021. The Victorian government's template for preparing a COVID plan references work sites, so it's very confusing for a residential only complex. Our building has minimal common property, just gardens and walkways. What information does the OC need to include in its plans, and does the complex still need a QR code or sign-in register?
Sure. So during COVID, a very challenging time for everyone, and for a lot of owners corporation management companies as well, especially when it came to trying to decipher the advice provided by governments. At times it was very vague, and especially when it comes to owners corporations. And I'm involved with an association called Strata Community Association Victoria, and I know that SCA tried very hard to lobby government to get some clear instructions as to what was required throughout COVID. But in terms of the point about the workplace, so the common property of an owners corporation, again, I'm not a lawyer, but my understanding is that it is deemed to be a workplace because contractors are engaged by the owners corporation and attend the property and carry out work. So an owners corporation needs to be mindful that it is in fact a workplace, and therefore my understanding is that an owners corporation must take out a COVID safe plan. So that COVID safe plan basically has to deal with looking at the risks associated with COVID, potential COVID cases, and looking at how the owners corporation can promote social distancing, and also looking at how registrations of visitors can be carried out. Now, recently, there was a directive by government stating that every owners corporation must print out a QR code and install that on the common areas of the property. Since that advice came out, SCA have gone back to government and clarified that it's not required. So social visitors or occupiers to a property are not required to constantly register their attendance. However, if there's a contractor or service provider that attends the common areas for more than 15 minutes, the obligation is that they must register their attendance via the QR code, scanning the QR code. So there are organisations out there, companies out there who will prepare a COVID-safe plan on behalf of an owners corporation, and sometimes it's very basic. It's just a template document which may have to be customised based upon a few factors. But so my understanding, it can be a couple $100 for an owners corporation, but then if it's a large property, that cost can certainly increase to be a lot more than that. So as owners corporation managers, we're not experts in terms of risk assessment of COVID and that type of thing. So certainly owners corporation managers shouldn't be preparing COVID safe plans. It should be an expert organisation, unless the owners corporation committee or a group of owners want to take it upon themselves to identify a risk and prepare that plan. But certainly an OC manager shouldn't be taking that risk on themselves.
Thank you. What approval process do I need to go through to renovate my unit? Do I need approval? Can the committee approve the works? In New South Wales, I know you need to create a bylaw. Is this how it works in Victoria? Are there minor works that don't need approval?
Sure. So yes, up in New South Wales, they're referred to as bylaws. Down here in Victoria, we call them rules, owners corporation rules. So there is the ability for an owners corporation to create rules. So there is the default rules, which are referred to as model rules of an owners corporation. However, the owners corporation can create additional rules in regard to certain things. So Schedule 1 of which adjoins the Owners Corporations Act stipulates what type of rules and categories an owners corporation can make rules under. One is in relation to the use of lots, and also my understanding is building works as well. So a lot of the time you'll see owners corporation rules refer to how the process for an owner to actually get their private works approved by the owners corporation. Some good practice is that basically there's a document that is sent to the owners corporation outlining the proposed works, and also how they're going to deal with any inconvenience that may arise affecting their neighbours. So whether it's noise or the delivery of building materials into the apartment complex, or a different type of owners corporation property. So whether it's how to book the lift and dealing with the owners corporation manager regarding that. So really important that the communication is there, that a lot owner informs the owners corporation manager, who in turn will inform the committee of management. There's also another requirement of the Owners Corporations Act that stipulates that if a lot owner is undertaking works that requires either a planning permit or a building permit, they must inform the owners corporation of the work. So when it comes to minor works that don't require such a permit, such as painting your apartment, my understanding is that you don't need to really inform the owners corporation of that. However, if it's major work that's going to cause, potentially structural changes to the apartments or create noise and inconvenience to others, then yes, approval will be required by the owners corporation by best practice.
Okay, and just on the same topic as well, we've had another similar question come in saying that a lot owner has obtained a permit from council to turn their garage into a bathroom, but did not advise the owners corporation. So now that the renovation has actually been completed, what should they do?
So in that regard, my belief would be that changing a garage to a bathroom would require a building permit. So my understanding would be that they would have needed to inform the owners corporation of the works. Obviously they didn't. So therefore, potentially they breached the Owners Corporations Act. So the Owners Corporation could follow Part 10 of the Owners Corporations Act, which is the dispute resolution section of the Act, and that is issuing a breach notice to the owner. But it may be futile because they've already done the works, and therefore the Owners Corporation could look to go to VCAT. I guess the question that has to be asked is, what is VCAT going to, I guess, determine in regard to the situation? Are they going to turn around saying, well, it's illegal, you can't do that? If council has provided approval for the works to proceed, it may be, VCAT may side with council saying, well, it's fine. There's also another requirement that stipulates if you change the use of a lot, that it affects the insurance taken out by the owner's corporation, then you could be liable for, well, you need to inform the owner's corporation, and potentially with this actually changes to the Owners Corporations Act coming in as of the 1st of December, as you mentioned before, Nikki. So that's going to require an individual lot owner, if they do change the use of a lot that affects the insurance premium, they're responsible for the increase in the insurance premium themselves. So something to be mindful of.
Okay, great. And we also have lots of questions that come in about renovating or doing renovations onto a balcony, or installing a shade outside, or painting a certain area that's you can actually see from the exterior of the lot, and so that causes some issues as well. Is that right?
Yes, certainly. So look, external appearance is usually covered under Owners Corporation rules. So if you are, even if it's within the confines of your lot, so whether it's on your balcony, if installing a window, furnishing of whatever type, if it's changed the external appearance, typically you require approval by the Owners Corporation. And I just saw a question pop up there. So I think the question was, do you have to go back to a general meeting of the Owners Corporation as a whole, or can you go back to the committee? So the committee is automatically delegated the powers to pass ordinary resolutions. So as long as the installation or the works aren't significantly changing the appearance of the lot, then the committee has the power to approve those works. If there's a significant alteration to the external appearance of the property, then you may have to get a special resolution to get those works approved.
Okay, excellent, thank you. And that same person, I think, has asked waterproofing works, for example. Does that affect the outcome at all, or?
When it comes to waterproofing, look, my view is that any of those types of work should be, the Owners Corporation should approve those works. Typically, people waterproofing are removing balcony tiles and replacing the waterproofing that way. So those types of works are destructive to the property, and therefore my view is that the Owners Corporation needs to provide approval. So yes, would be my response to that question.
Okay, great, thank you. All right, we're moving back to meetings again now. So this question is, why are unit owners not permitted to attend Owners Corporation meetings as silent observers?
I guess it comes down to the Owners Corporation. So here in Victoria, the Act is silent when it comes to observers at committee meetings. So it really comes down to the appetite of the committee. If the committee wishes for there to be observers, then that's fine, it's up to them, but they have the right to exclude other members from participating in committee meetings. Committee members have been elected by the greater membership or the other owners to represent them, and therefore that's their role to I guess discuss committee business and make those decisions on behalf of the Owners Corporation. So really the horses for courses type of scenario when it comes to observers and silence, I guess, visitors to a committee meeting.
Okay, and then similar, also talking about meeting minutes this time. Can the Owners Corporation's quarterly meeting minutes be sent to owners via email as opposed to have to look them up via an app?
Again, this is the determination of their fellow owners, being the committee management. The committee has the power to determine their proceedings, and if there's a quarterly committee meeting, they may wish to keep those minutes to themselves. They do form a record of the Owners Corporation, so they could be inspected at the office of the manager, or if there's no manager, then the secretary of the Owners Corporation. At times, some committees do actually circulate minutes to all owners for full transparency. However, some committees take the view that committee business, you need to really understand all the I guess the intricacies of the issues at hand, and therefore by circulating the minutes to the greater membership, that provides the owners to I guess ask a lot of queries, and which is not a bad thing, but at times it can take away, there's a lot of questions being asked, and it can take away the focus of the committee dealing with the owners corporation matters at hand. So again, not the manager's decision, but very much the decision of the committee how they wish to deal with that.
Okay. And I thought this one was actually really interesting. Given the three separate buildings at our complex, should there be a proportionate number of Owners Corporation committee member representatives for each building?
That's a good question, and we deal with this quite a bit in terms of an owners corporation being, or a property having multiple owners corporations. So you've got, if there are multiple owners corporations, you have an overarching owners corporation called Owners Corporation 1, being the unlimited, and then you have limited owners corporations in addition to that. So my view is that the unlimited owners corporation should have representatives from each of those limited owners corporations, and if not specifically on the committee, there should be a subcommittee that is created, or a working group where each of those buildings or limited owners corporations are represented. So very similar situation to what is posed there. If there's individual properties, there may not be limited owners corporations, there may just be the one owners corporation, but I would say that yes, there should be. However, the Owners Corporations Act is again silent on that. There's no requirement for there to be people from particular areas of the property representing owners on the committee.
Okay, and we have another one here to do with waterproofing membranes on a balcony. So we may have already covered it, but I'll just read through it in case there's something in there that you'd like to point out. I'm an owner of an apartment in a 5-storey building. The plan of subdivision notes that the location of boundaries defined by buildings are all interior face. Does this mean that the waterproof membrane on my balcony, which has turned out to be not so waterproof after all, is my private property and therefore my responsibility to repair, or common property and the responsibility of the Owners Corporation? The subpar membrane has also caused a couple of the tiles on my balcony to rise, and other lot owners in the building have similar issues.
Okay, good question. So when it comes to waterproofing, it really comes down to the boundary, and as mentioned, it is the internal face in this scenario. However, despite it being the internal face, there may be other conditions on the plan of subdivision or the strata plan that make reference to the location of waterproofing and tiles and that type of thing. So really important to look at the plan of subdivision strata plan in its entirety. If there's no conditions, then typically speaking, that the individual lot owner, if the boundary is internal face, interior face, the lot owner is responsible for the membrane. There is the Subdivision Registrar's Requirements Regulations 2011, which actually properly define the boundaries of a lot. So it talks about the interior face, the median face, and the external face. And it actually provides diagrams, and it goes into a bit of depth in regards to what is actually included and what's not. So whether it's the horizontal boundary being the membrane, or whether it's the vertical being the window boundary, it's really helpful actually. So my suggestion would be to consider that. But then there's also, I guess, the view that those regulations that came into effect, well, they were created in 2011, they may not be retrospective. However, if there is any, I guess, uncertainty about the boundary previously, my understanding is that lawyers do look upon those regulations and try to apply them, the logic retrospectively at VCAT, if it goes to there. So again, typically, yes, the lot owner would be responsible for the replacement of the membrane. However, there's a few other, I guess, tick boxes to tick to make sure that's the case.
Okay, thank you. That's a bit of a tricky one, isn't it?
It is.
In a certain situation. Okay, so this other one that we have is to do with choosing an OC management company again. So we're just being asked, what are the most important factors? And we probably covered a little bit of it previously, but
Yep.
what are the most important factors you think when choosing an OC management company?
Yeah, look, there's, I guess the role of an owner's corporation manager is very varied, and there is a lot of, I guess, misunderstanding, or probably not misunderstanding, but a lack of education when it comes to what the role of the owner's corporation manager is. It is quite diverse and a broad church, so to speak. So it is really important that when you're looking at an owner's corporation management company to appoint, that they have the experience dealing with a whole host of issues. So the experience as well as the competence to deal with financials, dealing with the compliance of the Owners Corporations Act. And just on that point there, a lot of, I guess, companies out there, they'll probably purport to be owners corporation managers, but really they're not managing the property that well. They're more owners corporation administrators. So basically doing the basic administration tasks and providing documents to the committee to consider. Really, the role of an owners corporation manager should be providing direction and good advice when it comes to Owners Corporation Act and Owners Corporation rules, compliance obligations, and also providing, I guess, insight into other situations that an Owners Corporation may be dealing with. So whether it's a waterproofing issue, they can rely on another situation they've dealt with to apply the, I guess, the logic and inform the committee of any challenges that they may have experienced in the other situation. So experience is vital. Good understanding of the Owners Corporations Act is integral. Other factors, it comes down to communication. So making sure that there's a good service level agreement when it comes to response times to owners, committees, making sure that the Owners Corporation manager who is appointed to the property has the time to liaise with the committee. Too often I get the question from prospective clients asking how many lots or how many properties are in the portfolio of the proposed manager. And it's really, it does, it intrigues me because it's quite shallow in terms of that question, because what a prospective Owners Corporation committee should be asking is, what other tasks the Owners Corporation manager is responsible for doing. So at the night, what we've done, we've decentralized the role of the Owners Corporation manager. So the manager is actually focusing on the high level Owners Corporation matters and dealing with the committee of management and other owners. And we've got other support staff who attend to the basic routine administration tasks, such as preparing minutes for meetings or dealing with insurance claims. And there's a whole host of things that we have to do. Ultimately, the Owners Corporation manager is responsible for managing the property and making sure that their support team members are doing the job as well. What else do prospective, I guess, people looking for a new manager, what should they look out for? It comes down to the structure of support as well in an organisation. So when that manager does go on leave, whether it's annual leave or sick leave at times, that they have a really rigorous process in terms of somebody filling in the void when that manager it goes away, because otherwise that manager may come back in 2 weeks and nothing's been done. So we've got a system where we've got the assistant manager step up, the team leader step down, and other support staff chiming in as well to make sure that any issues are dealt with during that period of time when somebody does go away. So I guess probably that's a summary of the pertinent things that people should look out for when it comes to choosing a manager, and someone who, it's hard to really understand this, but companies with good integrity. Unfortunately, this industry, well, fortunately, there's a lot of good players in this industry, but there's a few out there who spoil it for the rest. So making sure that everything is being disclosed properly to the Owners Corporation, making sure that they're not getting commissions on the side. Insurance commission, yes, is quite prevalent, but getting commissions from other service providers, we don't agree with that. So really asking some some of those questions to understand the ethics of those companies.
Okay, and you mentioned probably two things, Gregor, that I might just speak about. One of them was the misunderstanding. I think sometimes we find that in many instances, lot owners are under the impression that the strata manager actually makes the decision or directs the committee as well. So maybe is that something that you'd like to speak about?
Yeah, certainly. So yeah, a lot of the time, you know, we as the manager, we are the middle person, let's say. But our role, as I mentioned before, is to provide the guidance and the direction to the committee. When it comes to small decisions, it depends on the contract of appointment. You know, we can make some of the basic decisions on behalf of the owners corporation. You know, we delegated that power. But when it comes to the high level decisions, it rests with the owners corporation. And if there is a committee, as I said before, the committee is automatically delegated the power to pass those resolutions. So they're the ones calling the shots, and we're not the ones making the decisions. We don't have a vote when it comes to owners corporation matters. So yes, unfairly at times, owners corporation managers in the industry get targeted, where somebody may feel that they, I guess, they've issued a request to the owners corporation, they haven't got a decent response in their eyes, and therefore they take it out on the owners corporation manager when the owners corporation manager has had nothing to do with the decision. So yeah, look, it's unfair at times, but I guess that's it goes with the gig, and it's about education. So SCA and other good owners corporation management firms out there are always looking to educate lot owners in regards to how an owners corporation is configured, and what the process is if they've got an issue, and also the dispute resolution process if they're not comfortable with the response from the owners corporation. Yeah.
Excellent, thank you. And we have had another interesting question just coming from the audience now, and it's off topic. We haven't spoken about it so far, but it's to do with fireproofing and the cladding issues. So they're just being asked, is there any progress there, or do you have anything to report in that space at all?
Yeah, look, off the cuff, in terms of Cladding Safety Victoria, so an organisation that was set up by the government to deal with the combustible cladding installed on buildings. So my understanding was that they had $600 million of funding originally. They were actually associated with the VBA, which is the Victorian Building Authority. Recently, my understanding is that those two organisations have separated. So this CSV, Cladding Safety Victoria, now has to stand on their own 2 feet, so to speak. And I heard a comment the other day that a lot of the funding is going towards the administration of making sure that organisation can work. So going back to, I guess, the owners corporations that are affected, yes, there have been a number that have received funding from CSV to rectify the non-compliant aluminium composite panels, or the polystyrene, expanded polystyrene, the EPS. So although I haven't really heard much recently in regards to how much money there is still available to owners corporations, my understanding is that that money is going to dry up pretty quickly, and there'll be a lot of owners corporations that will be left to their own devices to rectify the cladding. I guess one of the biggest issues that we've found, and we do manage a number of properties affected, and so what we've identified is that the cladding is removed, or there's destructive testing to identify that the cladding is non-compliant, but also during that testing, they've identified that what's behind the cladding is also defective in terms of the building. So CSV will only fund the replacement of the cladding, not the rectification of the other non-compliant building, whether it's the construction of the facade. So the owners corporation will need to put their hand in their own pocket to fund those works. I was actually speaking with a company last week at a SCA conference, and that chap is in the business of lending monies to owners corporations, and their business is pretty busy at the moment because a lot of owners corporations are putting their hand out to fix these other issues aside from just the rectification of the cladding.
Okay, Thank you for the summary on what's happening. That's a great summary. Good to know.
I guess just further to that point, the process really, if you are experiencing a situation where you believe you've got cladding, engage an expert, and that expert should be either a fire engineer or a building surveyor. Get a report from them to understand whether there is any combustible cladding, non-compliant cladding installed, and then if the builder is still around, there's recourse back to the builder if the building is within 10 years. However, with that being said, I understand the government has extended the statutory warranty to 12 years. So 12 years from the date of occupancy of the building, the owners corporation has recourse back to the builder if they're still around. If the builder has died, disappeared, or become insolvent, then there's no recourse. And if the owners corporation has builder's warranty insurance, then they may be able to make a claim on that. Otherwise, they'll go to the CSV, Cladding Safety Victoria, to try and get funding to remedy the defect.
Okay. And we might just ask you to put your other hat on for a little while, because we've actually had a question come in about SCA, if that's okay. Do you mind
Sure.
at all? Or...
No, that's fine. Sure, definitely.
So following on from Gregor's comments on OC managers, so can the OC be a member of SCA? It doesn't look like our OC manager is a member.
Can an OC manager be a member? Is that what you're saying?
That's it. Can an OC manager be a member?
Yes, definitely. I guess the main, the majority of members are owners corporation managers. And so just a bit of background on the association, Strata Community Association. It's now a national Australasian body, I guess, because it now incorporates New Zealand. And then a lot of the states have their own chapters, their own bodies, and then there's a few chapters for territories. So there's a Victorian SCA, and as I said, majority of members are owners corporation managers. We've got a code of conduct that we require members to subscribe to. We're looking at how we can increase the professionalism of owners corporation managers in the industry. Other states, they've got licensing or minimum standards for education. We're currently looking at what the best, I guess, option is for Victoria, and really looking to advocate to government to introduce some of those requirements, because the barrier to entry to become an owners corporation manager at the moment is fairly low, and we're seeing some companies come into the industry where questionable in terms of their operations. So I guess it's a long-winded answer to that question. So in a nutshell, yes, your manager can become an SCA member.
Thank you. And LookUpStrata, we're supporters of SCA. We're actually a member of the WA chapter, and I'm on the education committee over there. So yeah, definitely, it's fantastic. Thanks very much, Gregor. Okay, well, we've probably got a few more questions in there, but that's probably all that we've got time for today. I can't believe that hour has just gone, it's gone so fast. If you did submit a question via email and we were not able to get to it during the session, please stand by for a response and we'll get something back to you over the next few weeks. And if you've submitted a question via chat and we ran out of time before addressing it, because there are quite a few still in there, please resubmit the question on our Ask a Strata question page on the LookUpStrata site, and we'll get back to you as soon as we can. And actually, just before we go, I might just mention too, Gregor, we did get asked, you mentioned about the document that illuminates the 3 different boundary types, and we've just had a question about that, and maybe if you can get the link to that through to me when we're sending the video out this afternoon, we'll actually include a link to that document in the video, in the email that we're sending out with the video, if that's okay. Definitely.
I'll quickly repeat it now. It's the Subdivision Registrar's Requirements Regulations 2011. So I'll certainly provide a link to you, Nikki, and you can provide that to your audience after this Q&A.
Excellent. Thank you so much. And before we go, I'd just like to say a really big thank you to you, Gregor, for the time that you've taken and all of the valuable information you've shared with our audience today. It was a real pleasure to have you with us. And at the end of the session, we always ask our guests to share any news that you have, recent achievements, new endeavours. And I believe you and the Knight have some exciting news you'd like to share with us.
Yes. So look, as a company in the industry, we're constantly looking at how we can lead the way in terms of not just owners corporation management, but other, I guess, matters affecting society. And we donate a lot of money to charities, and we've got an Australian Knight Award and that type of thing. But recently, we're looking at how we can improve the sustainability when it comes to not just our organisation, but owners corporations as well. So we've got some further news to share in the coming months, but we've partnered with another organisation where we're looking to create a tool to help owners corporations with navigating the hurdles when it comes to retrofitting sustainability initiatives within apartment complexes, which is really exciting. And we're also working on a few other things behind the scenes to really demonstrate that we're committed to sustainability across the organisation. So I won't make those announcements just yet, but feel free to follow us on our LinkedIn page and our Facebook page as well, and we'll be announcing those initiatives in the coming months. So that's in regard to sustainability, and also for a number of years we've actually provided grants to owners corporations regarding community building initiatives. So whether it's a resident's lunch or drinks in the foyer, creating community gardens, but part of the sustainability focus is now looking at providing grants to owners corporations for sustainability initiatives. We've already provided a grant to an owners corporation in our portfolio to help them with the installation of solar panels to the rooftop of their building. So just little things to really help push the promotion of these types of things throughout our portfolio properties.
Excellent. And we might be able to get some information out on that to our audience as well in the coming months.
Definitely, not a problem.
Okay, wonderful. So thank you so much for joining us, everybody, today. We hope to see you at one of our regular webinars in the future, and please keep an eye out for upcoming LookUpStrata events and publications. Thank you very much.
Thank you, Nikki, and thank you everybody for joining us. Cheers.
Goodbye.